When will we know if non-competes will actually be banned in the US? My guess is late July to early August. If that's enough for you, stop there. But if you want to know why, or if you like John Grisham novels, feel free to watch. I'm Ashley Hurd, and why am I talking about this? Because I was an employment lawyer and HR leader for years before I started Manager Method, where now I teach managers the fundamentals of people leadership, including some of the basics of employment law that are really important for managers to know. I also love taking really complex new rules and legal updates and breaking them down to make them make more sense. So I'll be talking about the non-compete rule. In this, we'll talk about whether it's going to take effect or not. Now, in a prior video, I talked about how it might not because of litigation. What does that mean? Well, in this case, the U.S. Federal Trade Commission, or FTC, is an agency that has issued this rule basically banning non-competes in the U.S. It'll uphold some non-competes for senior executives that are already in place before the rule takes effect. But after that, non-competes are not allowed except in very rare circumstances, like the sale of a business. So for employees, this has been huge news. Like, what does this mean? I don't have a non-compete? Not exactly. Even though the FTC's rule last week was called a final rule, it's not so final. That's because what can happen is that business groups and other groups can sue and say, no, this can't take effect because you don't have the right to issue this, the legal right. This is something only Congress can enact. And enact basically means pass a law. So they're saying that Congress should have decided this and that the FTC as a government agency, because it hasn't been elected in the same way that Congress is, doesn't have the right to do that. So that's the challenge that business groups are likely going to bring. And they have already. This is because on Tuesday, April 23rd, the same day that the FTC put its final rule out, at least two business-oriented groups, like the Chamber of Commerce, filed suits immediately asking for an injunction, which means that this rule should not go in effect. Now, if this hadn't happened and the rules just allowed to play out, it still wouldn't have taken effect Tuesday or any time this week. It takes 120 days from when it was published in the Federal Register, which is like the Wizard of Oz book. So basically, it would be about August 21st of this year that the non-compete ban would take effect. But these business groups filed suit that day. You may be thinking, boy, did those lawyers have to work quickly? Not exactly. Because of this proposed rule that had been put in place, a lot of these groups kind of knew what this final rule would likely look like. And so that's why they were able to immediately turn around, and some very, very expensive lawyers were able to file this lawsuit. So how do I know about this lawsuit? Did I file it? I did not. I'm not a party to any of this, but everybody can get access to these documents. Let me show you. So this is PACER. That stands for Public Access to Court Electronic Records. So this is for federal court cases. So in the U.S., you can file cases in federal court or in like state kind of local court. And so PACER is where you can get public access to any case that's filed in federal court and the documents that are in it. And it goes back a good amount of time. One note. PACER, which is pacer.uscourts.gov, had to check that, is free to register, but you have to pay for access to those records. And that's also something that people are suing PACER about, is having to pay for federal court records, but that's for another video. So when you have a PACER account, then you can look things up. So I looked up all of the cases filed against the Federal Trade Commission in the last week, because you can sort by like name of party and date. I guarantee most people aren't going to be looking this up, and that's fine. That's why I'm making this video. Now, the two main cases I'll talk about are the Chamber of Commerce suit and the Ryan LLC suit. Both of those are either business groups or a business firm that are suing the FTC in Texas, we'll talk about that, to basically say, hey, this rule shouldn't take effect in August. So judge, tell everyone that at least either one, we're going to halt this and not have it take effect until we can decide whether it's legal or not, or altogether just tell the FTC this isn't legal whatsoever. You don't have the authority to do this, so it won't take effect whatsoever. So again, both of these suits were filed on April 23rd. There's another one called ATS Tree Services LLC that was about the non-compete lawsuit. That was filed in Pennsylvania. That was filed on Thursday. But I personally suspect the Chamber of Commerce suit will probably get the most attention. But anyway, I won't go into that anymore. So when you go into these lawsuits, this is like the docket. Basically, this is like who's on the case. This is the list of lawyers. This is who brought the suit, which is the Chamber of Commerce, which is a business interest group. And some more like the Business Roundtable, the Texas Association of Business, and the Longview Chamber of Commerce, which is one of the places where the suit was brought in Texas. Now you'll see there's a lot of lawyers listed. That's like just how it is. Also, one of the big firms that's bringing this is Sullivan and Cromwell. You can think of this as the type of like a big law firm that would be the subject of a John Grisham novel. So, fun fact. For fun, I was looking up Jeffrey Wall, who's the head of the firm's litigation and Supreme Court appellate practice, to wonder what his hourly rate is. I couldn't find it. It's not always easy to find hourly rates, but Sullivan and Cromwell has billed out some of its lawyers what I've seen as high as almost $2,400 an hour. Yeah. Now, I noted that this case was brought in Texas. Specifically here, this is the Eastern District of Texas, which is Tyler, Texas. Now, one of the reasons business groups want to do this is because they want a judge that's likely to be more conservative, meaning siding with business groups. And Texas tends to have a number of judges that were appointed by Republican presidents, or tends to be more conservative judges often. Not always the case, because, for example, in the 2016 salary increase, when President Obama's Department of Labor had proposed a salary increase, they actually got assigned a Obama appointed judge in Texas who still struck it down. So anyway, we'll talk separately about the salary increase, but here, these business groups are really looking for those kind of employer-friendly judges. And they got one. They drew Judge J. Campbell Barker. Let's look him up. Now, let's look at Judge J. Campbell Barker. Now, he is young. I say that because he's either 43 or 44, which is about my age, so very young. But he was appointed by President Donald Trump. Why the business groups are likely happy with this draw is, for example, Judge Barker had previously struck down President Biden's National Labor Relations Board joint employer rule, which would have made it easier for franchisee employees to claim that a franchise parent company is their actual employer. And so that was a very employee-friendly rule. And he struck that down just a few days before it was going to take effect last fall. So he definitely has the history of rulings that these business groups that filed the lawsuit were probably pretty happy with this draw, would be my guess. Again, do not know them personally. So back to Pacer, when you look at the docket, you can see the list of all the filings so far in the case. And yes, this was just filed less than a week ago, but still has all of these filings. A lot of the filings so far are pro hoc vice motions, which are because a lot of these attorneys are Washington, D.C. attorneys that aren't licensed to practice in Texas. So they have to ask the court, hey, can we practice just for this case or just beyond this case? It's also why they have a Texas law firm that's helping them do all the filings to stay within the Texas rules. So one of the filings by the business groups, which are the plaintiffs, is a motion to stay the effective date and for motion for preliminary injunction. And again, what this basically means is, hey, this rule is supposed to take effect in August, but it's going to take time for us to hash out the legal arguments. So until we can hash those out, let's hold off on this rule actually taking effect. That's a very short version of what all these documents are asking for. One note, in this filing, the business groups say that they asked the commission to agree to hold off on enforcing this ban on non-competes until the litigation could be decided. And basically the FTC was like, no. So why did I say it might be late July, early August before we hear something on this? Because Judge Barker has already made up his mind a bit, on the schedule at least. So in this filing, he says, okay, I hear you. You're saying this is important, but I think this is important too. So in the order Friday, the judge says, because there's 120 days before this is going to take effect, we don't just need to decide whether there's going to be a temporary halt. We can decide the whole thing, which is called summary judgment. So now the business groups have until May 10th, so that's just a couple weeks, to file their motions, not just the one they already filed to have a preliminary halt, but that overall that this should be struck down as illegal. And then the government, the FTC, will have time to respond to that. But overall, so the judge set the legal briefing schedule, which is basically dates for the back and forth super long legal documents saying, this is legal, no it's not, this is legal. And so the last one is June 19th, 2024. Once the judge has all of those briefs, then he and his clerks will go back and take time to review them, look at the law, and decide whether the ban on non-competes should move forward or whether it should get struck down. And I say it should likely be late July to August because it takes time to go through that. So I wouldn't be surprised if this were to take effect August 21st, if it were literally days before that we get the decision from the judge. And that's not the end of it. Whatever the judge decides, then either the business groups or the government can appeal that ruling. So they can go to the Court of Appeals and then go up to eventually the Supreme Court. And because of the makeup of the Supreme Court, as pretty conservative now, again, I wouldn't be terribly surprised if the ban on non-competes was struck down. Not for a position either way on it, but because I could see the court saying that this is further beyond what the agency, the FTC, has authority for. And I mentioned this Ryan case. This isn't as advanced as the other cases, so I don't know what will happen with this, but fun fact, Antonin Scalia's son is one of the lawyers on it. But stay tuned. I'll be tracking this.